Imagine you're driving home late at night, or maybe you're just walking through a park, and suddenly those blue and red lights start flashing behind you. Your heart begins to race, and your palms get sweaty. Most people think that if they have nothing to hide, they have nothing to fear. They believe that being helpful, friendly, and talkative is the fastest way to get back to their day. But here is the biological and legal reality that can change your life in a split second. The police are trained in specialized interview techniques, designed to gather evidence, and that evidence isn't necessarily meant to prove your innocence. It is meant to build a case. There are three specific, seemingly innocent questions that police officers ask every single day, and answering them can never help you. In fact, it can only lead to a legal web that is almost impossible to untangle. Today, as a legal expert, I am pulling back the curtain on the conversational trap and explaining why your own biology is your worst enemy in these moments. We are diving deep into the three questions you must never answer, and the recent scientific discoveries in cognitive psychology that explain why the truth won't always set you free in the eyes of the law. To understand why you should stay quiet, we have to look at the power dynamic of a police encounter. When an officer approaches you, your brain immediately enters a state of high arousal. This is a survival mechanism. Your amygdala takes over, and your prefrontal cortex, the part of the brain responsible for complex decision-making and logic, starts to dim. In this stress state, you are prone to making tiny mistakes. You might get a date wrong, you might fumble your words, or you might try to fill the silence with nervous chatter. This is exactly what the legal system calls inconsistent statements. It's just a slip of the tongue, because you're nervous. To a prosecutor, it's evidence of deception. This is why the Fifth Amendment exists. It's not just for people with secrets. It is a shield for the innocent against the biological fallibility of the human mind under pressure. The first question you should never answer seems like the most polite one in the world. Do you know why I pulled you over? If you're on foot, do you know why I'm talking to you right now? On the surface, it sounds like the officer is giving you a chance to be honest. But from a legal perspective, this is a confession bait question. If you answer, I might have been going a little fast, or I probably rolled through that stop sign, you have just handed the officer a recorded confession on their body camera. You have waived your right to challenge the basis of the stop in court later. You see, the burden of proof is on the state. They have to tell you what you did wrong. When you answer this question, you are doing their job for them. The correct response isn't a lie. Never lie to the police, but a polite, I don't know, officer. It keeps the burden where it belongs and protects you from admitting to something you might not even have done. The second question is even more dangerous, because it feels like a casual conversation. Where are you coming from and where are you going? This sounds like small talk you'd have with a neighbor, but in a police encounter, it is a timeline audit. Officers are looking for any discrepancy between your story and the physical evidence. If you say you're coming from a friend's house but you're heading in the opposite direction, or if your passenger gives a slightly different location, you've just created reasonable suspicion. Recent studies in memory recall show that when humans are under stress, they often conflate locations or forget specific details of their route. An officer isn't going to give you the benefit of the doubt that you're just confused. They are going to use that inconsistency to justify a longer detention or a search of your vehicle. Your movements are your private business. A polite response like, I'm not comfortable discussing my day, but here is my license and registration, is your legal right. The third question is the consent trap. You don't mind if I take a quick look in your bag/car/pocket. Do you? If you have nothing to hide, it shouldn't be a problem. This is the most psychologically manipulative question in the police arsenal. It plays on our social desire to appear compliant and good. If you say yes, you are waiving your Fourth Amendment right against unreasonable searches and seizures. And here is the shocker. If an officer finds something you didn't even know was there, maybe a previous owner left something under the seat, or a friend dropped something in your bag, you are now legally responsible for it. Consent is a one-way street that only benefits the investigation. You have absolute authority to say, I do not consent to any searches. Saying no is not an admission of a secret. It is a protection of your constitutional privacy. Now let's look at the biological reality of an interrogation. Recent neurological discoveries have shown that the human brain under interrogation behaves differently than in normal social settings. There is a phenomenon called memory pliability, When someone in a position of authority asks a leading question, your brain can actually create false memories to satisfy the prompt. This is why so many people end up making statements that are later proven false by DNA or video evidence. They weren't lying. Their brains were literally rewired by the pressure of the encounter. This is the primary reason why staying silent is the only way to ensure your biological brain doesn't betray your legal interests. The lawyer's perspective on silence is often misunderstood by the public as being difficult. But think about it this way. The police are allowed to deceive you during an investigation. They can tell you they have a witness they don't have, or that your friend already talked. This is perfectly legal. However, if you make even a tiny mistake in your statement to them, you can be charged with obstruction or providing false information. It is an uneven playing field. Silence isn't about being rude. It is about symmetry. It is about ensuring that the rules of the game are fair. Let's dive deeper into the social psychology of the police encounter. There is a theory called the authority bias. Most of us are conditioned from childhood to answer questions when an adult or an official asks them. When we break that conditioning by saying, "I'm not answering questions," we feel a physical jolt of discomfort. Our heart rate spikes, and we feel guilty even if we've done nothing wrong. The police are trained to wait for that moment of discomfort. They use tactical silence to make you feel like you need to keep talking to fix the awkwardness. Don't fall for it. That silence is your best friend. It is the space where your rights live. One of the most important recent scientific discoveries in the field of law is the study of tone and perception. Data from thousands of body-worn cameras shows that officers often perceive non-compliance as aggression. This is why your delivery is just as important as your words. If you are aggressive or shouting your rights, you are escalating the situation and giving the officer a reason to ensure their safety through physical force. The most effective way to protect yourself is to be aggressively polite. Use the words "officer," "please," and "thank you," but remain firm on your rights. "I appreciate you doing your job, officer, but I am choosing to remain silent and I do not consent to any searches." This combination of politeness and firmness is a de-escalation tool that also protects your legal record. Let's discuss the traffic stop paradox. When you are pulled over, the law generally requires you to provide three things: your license, your registration, and your proof of insurance. You also have to provide your name if you are being detained. Beyond those identification requirements, there is almost nothing else you are legally obligated to say. Most people spend 20 minutes chatting with the officer about their job, their family, and their destination. Every word of that is potential evidence. Every and duh is being recorded. If you get into a legal battle later, that chat will be transcribed and used to show you were distracted, impaired, or deceptive. You are essentially giving a deposition on the side of the road without a lawyer present. The legal strategy behind silence is also about preserving the record. If you say nothing, your lawyer has a blank canvas to work with. They can challenge the officer's observations, the equipment used, and the legality of the stop. But if you have already provided an hour of context and explanations, your lawyer is boxed in. They have to work around your statements. You are effectively tying your lawyer's hands by trying to talk your way out of a ticket or an encounter. The best gift you can give your future defense is zero statements. Wait. What about the Miranda rights? Most people think the police have to read you your rights the moment they stop you. This is a Hollywood myth. Miranda only applies if you are in custodial interrogation. This means you are under arrest and they are asking you questions. If they just pull you over and start chatting, they don't have to read you anything, and everything you say is still admissible in court. This pre-Miranda window is where most people hurt their cases. They think that because they weren't read their rights, anything they say doesn't count. The truth is the opposite. The right to remain silent is always active, whether they read it to you or not. It is a passive right you must actively invoke. To actively invoke your right, you must speak up. Paradoxically, you have to talk to be silent. If you just stare at the officer and say nothing, the Supreme Court has ruled that this doesn't count as invoking your right. You have to say specifically, "I am invoking my right to remain silent, and I want a lawyer." Once you say those specific words, the interrogation must stop legally. Any questions they ask after that are generally inadmissible. This is the magic phrase of the legal system. It is your get-out-of-conversation card. Another fascinating discovery in forensic psychology is contextual bias. If an officer is looking for a specific type of suspect, say, Someone who just left a bar, everything about your behavior will be filtered through that drinking lens. If your eyes are red because of allergies, they see intoxication. If you fumble with your wallet because you're nervous, they see impaired motor skills. If you talk to them, your slurred words, which might just be your natural accent or dry mouth, become evidence. By not talking, you remove the auditory data they can use to confirm their bias. You are forcing them to rely on objective evidence, like chemical tests or video of your driving, which are much easier to challenge in court. There is also the reasonable person standard. In many legal situations, the court looks at what a reasonable person would do. Prosecutors often argue that a reasonable person wouldn't be afraid to talk to the police if they had nothing to hide. This is a presumption of guilt that we have to fight against. As a lawyer, I tell my clients, a reasonable person knows their rights and uses them. A reasonable person understands that the legal system is complex and that a sidewalk is no place to conduct a legal defense. By staying silent, you are acting as a legally informed person, which is the highest form of reasonable behavior. Let's talk about field sobriety tests. FSTs. These are often framed as a way to prove you're okay to drive. But biologically, these tests are designed for you to fail. They are divided attention tasks. Walking in a perfectly straight line while counting backwards is difficult even for a sober person on a gravel shoulder in the dark with headlights flashing in their eyes. Most importantly, in many states, these tests are voluntary. Would you like to step out and perform some tests? They are asking for your consent. You have the right to say, "Officer, I'm not comfortable doing those physical tests, but I will cooperate with the legal identification requirements." You are providing physical evidence of impairment that is entirely subjective and based on the officer's opinion. The legal discovery of body cams has changed the game, but not in the way people think. Body cams are great for showing police conduct, but they are also a permanent record of your worst moment. If you are angry, if you are crying, or if you are begging, the jury is going to see that. They won't see the full context of your life. They will see a 60-second clip of you at your most vulnerable. Silence preserves your dignity and prevents that emotional data from being used to bias a jury against you. Why do people still talk? It's called the urge to explain. Our social brain wants to correct the record. We think, if I just explain that my friend was the one who was yelling, the officer will understand. But the officer's job isn't to be your friend or your therapist. Their job is information gathering. They are closing doors on your possible defenses. If you say, "I was only at the bar for an hour," you have just closed the door on the defense that you weren't at the bar at all. You have locked yourself into a story that might not be fully accurate once you have time to sit down and check your receipts. Recent cognitive science studies on stress-induced amnesia show that people often forget the order of events when their fight or flight system is activated. If you give a statement during the stop and then give a different order of events in your official court testimony, the prosecutor will call you a liar. They will use that human biological error to destroy your credibility. This is why even innocent explanations are dangerous. You might be 40% wrong about the order of events, and that 40% error is enough to get you a conviction. Silence is the only way to avoid the memory trap. There is also an economic reality to this. If you talk your way into a charge, it will cost you thousands of dollars in legal fees to try to undo what you said. If you stay silent and get charged based on objective evidence, your legal defense is much more straightforward and often much less expensive. You are hiring yourself as your own first responder by staying silent. You are protecting your financial future by not giving the state a free win through your own words. Let's look at a real-world scenario. You are at a protest, or maybe just a crowded public event. An officer approaches and asks, "What are you guys up to tonight?" This is a consensual encounter. You aren't even being detained yet. But if you start answering, you are providing intelligence. You might accidentally name a person they are looking for, or mention a plan that they interpret as conspiracy. The best response to a casual public question from an officer is a friendly, "Just enjoying the evening, officer. Am I free to go, or am I being detained?" This status check forces the officer to either let you go or state a legal reason for holding you. It moves the encounter from social to legal, where your rights are strongest. The lawyer's mantra is "Don't help the state." The state has billions of dollars, thousands of officers, and a team of prosecutors. You have yourself and your rights. When you talk to the police, You are volunteering your mental labor to help them build a case against you. Every minute you spend explaining is a minute they don't have to spend doing actual investigation. Don't be a volunteer for the prosecution. Make them do the hard work of finding evidence that doesn't come directly from your mouth. Scientific discoveries and false confessions are perhaps the most chilling part of this legal landscape. We used to think that only guilty people confess. But the Innocence Project has shown that a huge percentage of exonerated people actually gave a full confession to a crime they didn't commit. Why? Through sleep deprivation, repetitive questioning, and psychological mirroring. The police are experts at making you feel like the only way to end the pressure is to say what they want to hear. They minimize the crime. Sigo. It was probably just an accident, right? And maximize the evidence. Ixin, we have your prints everywhere. Under that pressure, the human brain snaps and enters a state of compliance over truth. Staying silent from the very first second prevents this psychological breaking from ever starting. Let's recap the big three. Officer. Number 2. Where are you coming from? Answer. I'm not discussing my day, but here are my documents. Number 3. Can I search your car? Answer. I do not consent to any searches. Beyond that, your only phrase should be, I am invoking my right to remain silent, and I want to speak to my lawyer. If you can remember those 4 things, you have more legal protection than 99% of the population. Some people worry that being silent will make the officer mad. It might. They might give you a ticket they were going to let you off for. But a ticket is a minor inconvenience. A criminal charge or a confession that leads to a legal record is a lifelong burden. Don't trade your long-term freedom for short-term approval from an officer. Their approval doesn't matter in the courtroom. Your rights are the only things that have currency. Wait. What about helping the police catch a bad guy? If you are a witness to a crime, the same rules apply. You should still speak to a lawyer before giving a formal statement. Why? Because as a witness, you are still providing evidence. If you get a detail wrong, or if the bad guy has a better lawyer than you, they might try to turn the tables and make you look like a co-conspirator. Even good citizens need legal protection. The truth is a subjective thing in a courtroom. A lawyer-vetted statement is a legal shield. Recent criminology data shows that body-worn cameras have reduced some forms of police misconduct. That digital twin can't be intimidated or nervous. It just provides facts. By staying silent, you are ensuring that your digital twin is as clean and silent as possible. You are managing your legal reputation in the digital vaults of the police department. There is also the social media factor. Today, a police encounter isn't just between you and the officer. It's between you, the officer, and millions of potential viewers on YouTube or TikTok. If you stay silent and remain polite, you win the PR battle as well as the legal battle. If you are screaming about your rights and reciting sovereign citizen myths, you look like a variable. You look like trouble. The lawyer explains method is about being the coolest person on the scene. It's about being professional in the face of authority. The scientific discovery of implicit bias also tells us that officers might subconsciously interpret talking back as a challenge to their alpha status. This is a biological dominance display. When you stay silent but remain physically compliant, keeping your hands visible, not making sudden moves, you are deactivating the dominance reflex in the officer. You are making yourself boring. And boring is exactly what you want to be during a police encounter. You want to be the standard stop that they forget 10 minutes later. What if you're in a stop and frisk state? The law there says they can pat you down for weapons if they have a reasonable fear. You can't stop the physical pat down without risking an assault charge. But you can and should state clearly, I am not resisting, but I do not consent to this search. This verbal objection is your legal anchor. It allows your lawyer to challenge the basis of the frisk later. If you don't object, the court assumes you consented to the touching. Your voice is your legal barrier. Let's talk about the phone. If an officer asks for your phone passcode or asks to see what you're doing, the answer is a hard no. Your phone is a personal data vault that contains more information about you than your own brain can remember. Legally, the police almost always need a warrant to search your phone. Don't give away the keys to your digital life just because you want to be helpful. If they want the phone, make them ask a judge first. That judicial oversight is your check and balance. The law is a language. The police speak investigation. The prosecutors speak conviction. You need to speak protection. By limiting your words to the big three and the magic phrase, you are translating your situation into a language where you have the upper hand. You are moving from a reactive state of biological fear to a proactive state of legal empowerment. The count of your rights is always active. You have the right to remain silent, the right to counsel, and the right to be free from unreasonable search. These aren't just old words on a parchment. They are living protections that work every time you use them. The only way they fail is if you give them up through a conversational error. The scientific community, the legal community, and the civil rights community all agree on one thing. The more you talk, the more you lose. Whether you are a law-abiding citizen or someone in trouble, the physics of the law are the same. A statement is a weight. If you carry too many weights, you will sink in the legal sea. Silence is your life jacket. So, the next time you see those lights or hear that "excuse me, sir," remember this guide. Remember that your biology wants you to explain, but your legal health requires you to wait. Be polite, be compliant with physical orders, but be a vault when it comes to information. You are not hiding anything. You are protecting the human right to privacy. That is the foundation of a free society. The Lawyer Explains series is about equipping you with the tools to navigate the modern world. The police encounter is one of the most stressful social transitions a person can go through. But by understanding the three questions and the scientific realities of interrogation, you can walk away with your rights, your dignity, and your record intact. Stay curious about the law. It is the code that runs our society. The more you decode it, the more freedom you actually have. The history of justice is the history of people invoking their rights. Be a part of that history. Stand your ground, keep your mouth shut, and let your lawyer do the talking. That is how you survive the police encounter. The final word on this is consistency. Don't start out silent and then give in 10 minutes later. That inconsistency is used to show you were hiding something and finally snaped. Pick your legal strategy, silence, and stick to it until the encounter is over. It is a test of will, and you have the will to win. The lights will stop flashing. The officer will walk away, and you will go home with the most important thing of all, your future. That is the revealed truth of the police law. It is a discovery that keeps you free, and that is a fact that leaves the prosecution speechless.